Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Luqmanul Hakim bin Rasdi, number metric 2212211, and now I will present about the topic of position of Islamic law under Federal Constitution and its challenges as the official religion of the country. Islamic law is not a legal system but a legal tradition, much like the common or civil law tradition. A legal tradition is a set of related beliefs, attitudes, and practices regarding the necessary components of a legal system, including the scope and purpose of the law. They also use Sharia law. There are four primary sources of Sharia law. Firstly is the Quranul Karim, which means the holy books. The holy books is conveyed from Allah Subhanahu wa Taala and sent to His messengers and relayed by the Prophet. Secondly, the Hadith or narrative of the Sunnah of the Prophet Sallallahu Alaihi Wasallam constitutes the rules of faith of the Muslim community. Then, Ijma. It contains the opinions of Islam's learned scholars on matters. Imam Al-Ghazali rahimahullah defined Ijma by saying the agreement of the people of Muhammad sallallahu alaihi wasallam on a matter of religious. And finally, Qiyas. Qiyas is the process of comparing difficult questions of doctrine with similar cases settled by the authority of the Holy Book, which means Quran Karim and Sunnah. Next will be the Federal Constitution. Federal Constitution is a law which some countries use to develop their countries. It's also a set of rules that describes how the Federal Parliament works, what it can make laws about, and how it shares its power with the states. The Constitution sets out the three arms of the federal government, which means is parliament, executive government, and judiciary. Next, I will pass to the next presenter.
Bismillahirrahmanirrahim. My name is Syafiq and my metric number 21011, and I will explain the reason of the emergence and implementation of Islamic law. Okay, since the Sharia originated from Allah Subhanahu wa Taala, Muslim consider it as scarce between the 7th century to the 10th century. Many Islamic legal scholars attempt to interpret the Sharia and to adapt in expanding Muslim empire. Okay, let's go to the reason of the emergence. Before Islam, the nomadic tribe inhabiting the Arab Peninsula worship idols. This tribe frequently fought with one another. Each tribe had its own custom governing marriage, hospitality, and revenge. Crimes against person were answered with personal retribution or were sometimes resolved by an arbitrator. And when Prophet Muhammad born, Prophet Muhammad introduced a new religion into this chaotic Arab world, which is Islam. Islam affirmed only one true God. It demands that believers obey God's only one God and obeys God's will and laws. Okay. The Quran set down basic standard of human conduct, but does not provide a detailed law. Only a few verses deal with legal matter. During his lifetime, Prophet Muhammad clarified the law by interpreting provision in the Quran and acting as a judge. Thus, Islamic law, the Sharia, became an integral part of the Muslim religion. After Prophet Muhammad died, the companion Prophet Muhammad ruled Arabia for about 30 years. Political religious ruler called Khalifah continue develop Islamic law with their own pronouncement and decision. The first Caliph also conquered Iraq, Syria, Palestine, Persia, Egypt. As a result, elements of Jewish, Greek, Roman, Persian, Christian church law also influenced the development of the Sharia. Islamic law grew along with the expanding Muslim empire, the Umayyad Empire, Osman Empire, and then after 500-year rules under the absolute rule, the Abbasid transferred substantial area of criminal law from the Qadis to the government. The Qadis continue to handle cases involving religion, family, property and commercial law. The Abbasids encouraged legal scholars to debate the Sharia vigorously. One group held that only the divinely inspired Quran and teaching of the Prophet Muhammad. After that, in an attempt to reconcile the rival group, a brilliant legal scholar named Syafiq systemized and developed what we call root of the law. Yakni Syafiq argue that in solving a legal question, the Qadi or government judge should first consult the Quran. If his answer were not clear there, the judge should refer to the authentic saying and decision of Muhammad. If the answer continue to elude the judge, he should then look the consequences of Muslim legal scholar on the matter. Okay. Syafi'i provoked controversy. He constantly criticized what he called people of reason, people of tradition. While speaking in Egypt in 820 years, he was physically attacked by opponent. After around 900 years, the classic Sharia had taken shape. Islamic especially and law assembly handbook judge to use in making their decision. The classic Sharia was not a court of law but a body of religious and legal scholarship. Thank you for me.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Akil bin Azhar Shah. So today I would like to continue on the next topic, which is the characteristic of Islamic law in Malaysia. First, I will talk about the position of Islam in Malaysia, the act refer to it, and the jurisdiction of Islamic law in Malaysia. Firstly, Islam in Malaysia is sacred and cannot be denied the existence of it, and it is an official religion for Federal Constitution. Act 3 Clause 1 indicates that Islam is the religion of the Federation, but other religion may be practiced in peace and harmony in any part of the Federation, which means we can say that Islam is a dominant religion in Malaysia rather than the other religion. And to back this up, we have Article 11 Clause 1, which reaffirms the supremacy of the position of Islam under Constitution. And we also have Act 11 Clause 4, which gives prohibition to other religion to preach their ideology to a Muslim. However, there are two views on position of Islam in Malaysia. First, Islam is limited to ceremony and custom. From the case of Cik Omar bin Cesok versus public prosecutor, the Supreme Court have held that the Cik Omar give the death penalty, which is contradict with the Islamic law. The second view is Islam should be interpreted as one complete living system in Malaysia. From the case of Lin Ajoy versus Mawib, the Supreme Court have held that Islam is not just a ritual and dogmas, but a complete way of life, covering all fields of human activities. Next, regarding the Islamic law, the jurisdiction, it is generally limited in its jurisdiction. This is due to the Federal Constitution being the highest law, which means if any law contradicts with the Federal Constitution, then the law will be invalid. The Islamic law also applies to only Muslim. For example, in the month of Ramadan, if a Muslim break their fast, which is by drinking or eating in public, they can be charged for the activity. And the Sharia court can only hear cases that listed under list 2 in the 9th schedule of Federal Constitution. And it also can be said that civil court have wider jurisdiction to hear cases rather than the Sharia court.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Fauzan Irhami bin Farid Zuhri. Alright, right now we move to the next topic, which is the topic of sources of Islamic law under the Federal Constitution. Alright, before the arrival of the colonists in Malaya, Islamic law had already been accepted in the custom of the local community. Western scholars such as M.B. Hooker claim that the Malay custom was a separate matter from the Sharia. Islamic law was enacted under the Federal Constitution in Malaysia, and YDP Negeri is the head of Islam in its home state. Its primary objective is social justice, which includes property rights, economic decision making, and types of economic freedom. Then, the Federal Constitution of Malaysia states that Islam is the religion of the Federation, which means that Islam is the religion being practiced in the 14 states. Alright, there are various sources of Islamic law used by Islamic jurisprudence to elucidate the Sharia. The primary source of Islamic law is the Quran, which is thought to be the authentic word of God sent to Muhammad by the angel Jibril in Mecca and Medina. Then, the Sunnah, which encompasses Muhammad's commonplace, comments and utterance, is the next significant sources. The Ijma' or agreement among Muslim jurists on a specific legal matter is the third source of law. Finally, Qiyas or analogous deduction is the fourth source of Sharia for Islamic law. Qiyas must be solidly entrenched in the main source rather than being dependent on arbitrary judgment. Alright, next we move to what the comparison between civil law and Islamic law under the Federal Constitution. Sharia law is divisive legal system that is practiced in 15 Muslim nations in the Middle East and Asia. It is based on the Holy Quran, Hadith, Sunnah and Ijma', and dates back to the early days of Islam. Hudud is a part of Sharia law, but it is limited and can only be used in Islamic states. The UN and Human Rights Organization have voiced their concerns about this practice, and Brunei introduced a Sharia-based penal code in 2019. Sharia law in Malaysia only applies to Muslim and is granted exclusive jurisdiction by the Sharia courts. The majority of Malaysian law is secular civil law deriving from the British common law system and fundamental legislative laws. The clash between civil and Sharia law in Malaysia's legal system is the result of duality of the system. An example of this, the Indira Gandhi case, where a Hindu mother's husband converted to Islam and took their children away from her. This case established a precedent that Sharia courts would not have jurisdiction if one of the parties is not a Muslim. This was necessary to protect non-Muslim rights to a fair trial. Malaysia has both civil and Sharia law, which reflects the cultural values and mentalities of the nation. Tolerance and respect must be prevail of homogeneity to maintain Malaysia's identity as a melting pot of cultures. However, Malaysia still have a long way to go before turning tolerance into acceptance and celebration. That's all from me. Thank you so much.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Zal Aziz bin Zainal. My metric number 2217095. In this video, I will explain and I will present about some important literature that related to these topics. First journal that I think is so related to this topic, which is the journal about implementing Islamic law within a modern constitutional framework and challenge and problems in contemporary Malaysia, written by Hamid and Ahmad Fauzi Abdul. This journal show that some Muslim countries in the post-colonial period faced with the challenge of developing political structure consistent with Islamic teaching. The uniqueness of the task term, the fact that this structure have to be raised in a constitutional framework very different from their historical experience until modern times. Besides that, this journal also explains the case of Malaysia, whose federal constitution proclaims Islam to be as Malaysia's official religion. And beside that, the second journal that I think also important related to this issue, which is the journal about some about challenges to application of hudud in Malaysia, and which is an evaluate study written by Iqbal and Muhammad Saud. In this article or in this journal, it said about the hudud crimes and punishment in Islamic criminal law. Maybe the most contentious aspect of Islamic law today. While many Muslim majority countries may want to implement hudud in their country, and there are also modern constitution nation in a global environment dominated by the human rights movement. This journal also evaluates the major methodological, constitutional, legislative, and human rights challenges facing hudud implementation in Malaysia, a nation that has Islamic embedded in its pre-colonial history, constitution, and legal system. After we know some example of literature that related to this topic, I also want to give some example of country that implement Islamic law. About half of the world Muslim majority country have some Sharia based law, typically governing areas such as in marriage, divorce, inheritance, and also child custody. Only about a dozen of Muslim countries apply Sharia to criminal law in part or in full. Besides that, European style law also influences legal system in Muslim country, even in Iran and also Saudi Arabia, which the country that claim that they are only follow Islamic law. They also in part to the effect of the colonialism, the requirement for economic modernization, and also the fact that many of elite who built the legal system in Muslim majority country had Western education. An opinion on the best balance of Islamic law in secular law vary. The political system tend to incorporate Sharia-based law in among three ways. First way, which is the world legal system. In some countries with large Muslim population, such as Malaysia and Nigeria, the government has a secular judicial system, but Muslims can choose to bring certain matter to Islamic court. The exact jurisdiction of this court varies by country, but usually include marriage, divorce, inheritance, and also guardianship. Then the second way, which is government under God. In country where the Islam is the official religion, the constitution designed Sharia as a source or as the source of law. As example of the former include Afghanistan, Saudi Arabia, while the country like Bahrain, Kuwait, and also UAE are among the country that apply Islamic law in personal, but not in civil or criminal law or criminal matter. But in Pakistan, Iraq, and Iran, among other, it's forbidden to them to enact legislation that is antithetical to Islam. And non-Muslim are not expected to obey Sharia, and in most countries they are under jurisdiction of special government committees and adjunct courts. Next, the last way, which is the secularism. Muslim countries where the government is formally secular include Azerbaijan, Senegal, Somalia, Tajikistan, and also Turkey. Still, Islamist parties run for office and occasionally take power in this country, such as Turkey's ruling Justice and Development Party, which is AKP, is such as example of them. That's all from me. Thank you.
As we know, Islamic law appeared when the revelation to Prophet Muhammad SAW began, and still continue with the era of the previous companions and the Tabi'in, and followed by the era of Mujtahid, Imams, and Mazhab, who also issued their opinions based on this law. We must care and defend it from enemies of Islam to continue the spreading of Islam to all humankind. That's all from us. Thank you for lending your ears, and wassalamualaikum warahmatullahi wabarakatuh.